Hi, I'm Micah Clark. Thank you for joining us today. As you know, this is the first week of the Indiana General Assembly. And it started off with a bang on Wednesday. There was a wonderful prayer service Matt Barnes did, which he does every year. It does a great job. And then after that, the Indiana Senate went into session and the House as well. But there was a Senate bill we were watching that had a hearing Wednesday afternoon. And my guest today testified on Senate Bill 143. Now, Senate Bill 143, we've talked about a lot. It's a parental rights bill. This is the second or third year we've seen this filed. I saw an original version of this I worked on back in 1995 when I worked for the Indiana Family Institute, who our guest is with today. So this is not a new concept. Many states have this bill. By the way, I made a mistake in an email yesterday. I said 60% of the states have a parental rights bill, according to parentalrights.org. Actually, it's 40%. That was my mistake. But it still makes the point that this is not new ground we're treading. This is a law that is pretty well known. And so I'm excited to have a good friend on here with the Indiana Family Institute, Josh Hershberger. He's an attorney. He did a phenomenal job testifying on Wednesday. So I wanted to have him on today because there's a little bit of confusion about this bill we're going to talk about. But Josh, first of all, thank you for joining us. I know you're busy. You're in a hotel room at the moment. But tell us why Indiana needs a parental rights bill in Senate Bill 143.
Thanks, Mike. I appreciate your interest in this bill and the focus on it and the help in spreading the word about what this bill is about. So just personally, I represented a family for 2 years. Your listeners may be familiar with Mary and Jeremy Cox. They're just heartbreaking story. They're raising their child, doing everything they can to raise him according to their beliefs, but also their best judgment as parents. He declared himself to be transgender. They were providing for all of his medical needs, his educational needs, and despite that, the state came in and claimed that they were neglecting him because they were not affirming his transgender identity, as well as not providing treatment for an eating condition, which was completely false. They were following their doctor's recommendations. They had scheduled appointments with a specialist, and yet DCS argued at the removal hearing, and just get this, this is the line, we just feel that this is a biological male, that she should be in a home where she is accepted for who she is. 5 months later, he's pulled out of their home. They're barred from speaking to him about their faith. 5 months later, the state dismissed all allegations against the family and yet kept him out of their custody for more than 2 years, eventually aging out. Despite all efforts up to the Supreme Court, a separate suit in federal court, we got no remedy anywhere. And so clearly, parental rights needs to be defended, supported. One other specific example, I serve as local counsel for Kathy McCord, a counselor right here in Indiana. And all she did was, in her personal capacity as a citizen of Indiana, United States, confirm that one of our schools, South Madison, was withholding information from parents about social transition at school. Listeners may be familiar with that. And so these are two just right here in Indiana. These are Hoosier examples of parental rights not being protected. Now, at the federal level, we have case law that confirms that the right of parents to raise their children, it's one of the oldest, the most fundamental liberty interest. And listeners can imagine, what good is freedom of speech? What good is freedom of religion if you don't have the right to raise your kids and the state can come in and take them? And so that was the genesis of this bill. We need to, in Indiana law, take that federal standard and make sure that parents have their rights upheld in our state law, our state courts. So that was the genesis of the bill.
Well, and there was other attorneys who testified with similar cases where they'd run into roadblocks and felt like their clients, the parents, had been mistreated. Something hit us this year, and I guess a little bit last year. We didn't think too much of it last year. But this year we had some people who started making calls who had read the bill, didn't understand the bill, in my view, and are concerned about a section of the bill. And a lot of these folks are friends of ours, people we know. But the best way I can explain it, not being an attorney, is when you read this section, if you don't understand something called strict scrutiny, which I'll have you explain, and legalese, the way they're reading this is a misreading of something. And the section is on page 4, Article 42. It says, governmental entity may not substantially burden a parent's fundamental right to direct the upbringing, religious instruction, education, or health care of the child's of the parent's child unless the burden is in furtherance of a compelling government interest as in the least restrictive means of furthering the governmental interest. Now, I've seen that code in other places for other issues. It didn't surprise me, but I think the concern some parents have, or some activists have, is they think the government can say everything is a compelling interest. It's actually just the opposite. That's what they can do now. And so if I say that right, I'll let you explain that section as an attorney and why I think some people are misunderstanding this section of the bill.
And it is, in a sense, legalese. I wish there was just an easier, simpler way to go about it.
Mm-hmm.
But the idea of strict scrutiny, there are essentially three tiers of legal scrutiny. And the way this works is if someone believes, hey, you have infringed on a constitutional right of mine, and that would be freedom of speech, freedom of religion, the Second Amendment, the right to bear arms. If you go to court, if it is not an established right, you get just basic level scrutiny. It's called rational basis. It's kind of like maybe a judge kind of just holding it up and kind of eyeballing it, like, oh no, that's okay. I'm not going to really dive deeply into this and scrutinize what the government's doing.
Mm-hmm.
There's an intermediate level of scrutiny and kind of gender issues, but then the strongest level of scrutiny, the one that preserves our most cherished rights, is called strict scrutiny. And that's exactly the standard that's put in this. This is the strongest legal protection available. And
Mm-hmm.
what it means is if a parent comes to court saying, look, you didn't give me access to my child's medical records when you accused me of abuse or neglect, or you withheld school, you withheld information from me about my own child. And if they file that lawsuit, the court has to pull out what I would say is the legal microscope. And they're
Mm-hmm.
going to ratchet down on that, and they're going to look at it very, very closely. And there are a couple examples I think that listeners might be familiar with. You think of Jack Phillips, who finally
Mm-hmm.
won his case saying, I serve all people, I just don't create all messages. And I'm not going to create a cake that goes against my beliefs. Why did he win that? Because his beliefs merited strict scrutiny. I
Mm-hmm.
know there's a lot of leftover feelings. I don't want to talk about 2020 and COVID. Everyone's, no, it's over. Let's not talk about it anymore. But I know that's in the back of our minds. Well,
Mm-hmm.
why did the Catholic Archdiocese in New York finally win its case saying, look, you're treating the church differently than a similar secular entity? It was because their claims were subject to strict scrutiny. And what we're saying is that right now, when parents go to a trial court and they're saying, hey, you have run over our parental rights. It's
Mm-hmm.
a fundamental right. The courts are just kind of shrugging in our Indiana state courts. You can try to go out to federal courts, but it's very difficult to do. It's very expensive. The state can come into our homes, and that is a county level decision. We
Mm-hmm.
have county departments of Department of Child Services. We have local school boards, and the state can come in at the county level and infringe on parental rights. And what we're saying is that we need to level the playing ground here. And
Mm-hmm.
parents need to be able to go down to their local courthouse square family law attorney and have a statute that says, hey, here's an infringement, and
Mm-hmm.
here's a way that you can go file an action and you can get attorney's fees if the state has violated that. So it is a bit of legalese. And I understand looking at it, if you haven't kind of tracked what's been going on this whole
Mm-hmm.
time, where there could be some confusion. But if there were a stronger level of scrutiny, I would love to put that in the bill. But
Mm-hmm.
that's what is available to us in the law right now. And so that's why that particular provision is in there.
Well, you kind of answered where I was thinking in my head during the committee hearing. One legislator in particular, maybe two, brought up this issue, and he was speaking about COVID, and he was talking about, the government had compelling interest in made us wear masks and all this stuff, but he didn't really have an answer for better language than we have here. And my understanding is when the person on the street reads this, they see it one way. When a judge reads this, they understand what this means. So there really, like you said, there really isn't a stronger method, or we would support it. Is that accurate?
That's correct. And understand that in case law, what is a compelling interest in a
Mm-hmm.
parental rights arena? This is very well settled in law. For example, Troxel versus Granville. This is parents have the right to determine who has custody, who
Mm-hmm.
has visitation rights. Parham versus JR at the Supreme Court. Parents, not the state, gets to determine the mental health care of a child. You think of Stanley versus Illinois. This secures
Mm-hmm.
the right of dads to have custody of kids. We have Wisconsin versus Yoder, the ability to raise our kids according to our beliefs. And so this has been well outlined in case law.
Hmm.
It's not like the government can just dream up something and say, "Oh, this is a compelling interest."
Right.
We
Right.
have about 100 years worth of case law that's
Right.
established the the guidelines here.
Hmm.
And this is just saying, court, you've got to pull the microscope out whenever it has to do with parental rights.
Well, Josh, I want to thank you for all you did yesterday. You did a phenomenal job testifying. I was down at the State House, had to come back from a meeting here, and I watched it, but I didn't catch all your testimony. I missed the last two people who testified, and then I came back and saw the one opponent who testified. And I wanted to ask you about that. Obviously, it was the ACLU. What in the world was he saying? And is that anything? Did the opponents, official opponents of this, have any merit? And was he arguing for children's rights superseding parental rights? I didn't catch all of his testimony. Um, in my view, if the ACLU is against something, it's probably a good good bill. But what was his argument?
So I had stepped out into the hall to a
Okay,
degree, caught up just a bit of it. So I don't want to represent all of it. I
sure.
do know what has been argued in the past was even in a sense, kind of a privacy right for children, especially older teens, that in a sense that they could supersede the right of
Hmm.
parents to direct their upbringing. And just let that sink in for a moment. Like
Right.
that is an approach that's being pushed even in our state, that kids need to be able to make decisions
Hmm.
for themselves, even over against their parents. And from a biblical perspective, it is the parent's duty. And from a
Absolutely.
constitutional perspective, it is the parent's constitutional right to direct that. A couple of things that have been raised had to do with just overwhelming the court system. And in fact, a question was raised about, well, we don't want government officials to be nervous about, violating rights when they're doing their
Hmm.
job. And
Hmm.
no, actually, we do want
Right.
government officials to be thinking about constitutional rights
Right.
when they're interacting with families. It's like a
Hmm.
police officer.
Hmm.
If he is doing his job of protecting safety, I absolutely want him to be thinking about my Fourth
Hmm.
Amendment rights.
Hmm.
And so the same is true of DCS when they're interacting with parents. And so I said, well, that's not a flaw. That's the feature of the bill. Yes, we want this should not be shrugged off. This
Right.
is a fundamental right.
Well, I want people to call their legislator, call their state senator. We're talking about Senate Bill 143. Please call your senator, ask them to support SB 143. That would help us out a lot as we go through the process. Next week, we hope they will vote out of committee and move it on to the floor for further debate. But your support means all the difference in the world because they are getting some phone calls from some people who don't understand this. Josh did a great job explaining it. Please call your legislator. We'll have that information down below in the link. But Josh, thank you for joining us today. Appreciate all you do at IFI. And again, you did a great job yesterday as you did last year when I was there as well. So thanks for standing for faith and families like you've done so well.
Well, thank you, Micah, for the support and for helping spread the word about what this bill is doing.
Well, I hope that helps clear up some of the confusion about Senate Bill 143. Feel free to email me if you have questions, but I encourage you to share this video with friends as well who are interested in this issue because I think you really explained it very well as to why this is a good bill, not a bad bill. So Senate Bill 143, we've got hundreds of bills that have been filed, hundreds more we're expecting to see. We'll try and keep you on top of what we think is going to move and what we think is important through our weekly email and these Friday videos. But until then, I'm Micah Clark with the American Family Association. Have a wonderful weekend.